Hi, my name is Perry Salzhauer. I'm a founding partner at Greenlight Law Group. I head our corporate transactions and licensing practice, and I'm here today to talk about some of the most common questions that I hear from people who are either getting into the adult use cannabis industry for the first time, or sometimes legacy market participants who are entering the adult use cannabis market and for whom this might be their first legitimate business. So one of the first questions that I get from potential clients is, I have a few LLCs, can I use one of those or should I start a new LLC? And the answer is 100% of the time, you should start a new company. The reason for this is because there is an archaic provision in the Internal Revenue Code called 280E, and we'll talk more about that later. I always get into that in these conversations. And it impacts cannabis businesses and no other type of business that's currently operating in the United States. And it's very important that you don't taint your existing businesses with the potential liabilities associated with 280E. Of course, probably the first or second question is always, how do I get a license? What do I need to do to get a license? And the answer, although it varies from jurisdiction to jurisdiction, is almost invariably the same three things. 1, form a legal entity. 2, find a location. And 3, apply for a license. Now, how you apply for a license varies from jurisdiction to jurisdiction in terms of the requirements, but every jurisdiction has a few things in common. And that's why the answer is always the same. They always want to know, where are you going to be operating and who is the licensee? And those questions speak to entity formation and selection and location and site design. This always leads to the next question. Well, what type of business should I open? What type of entity should I form? And folks are always wanting a quick and dirty answer to that so that they can, run off to the Secretary of State or Department of State website and form a company. Now, unfortunately, the answer to that question is probably the most complicated because entity selection is so intricately tied with tax strategy that there is no one-size-fits-all answer to this. The reality is, entity selection is a decision that needs to be made in conjunction with your attorney, your CPA, and not just any CPA, a CPA with a cannabis specialty who will understand 280E, and the individual ultimate beneficial owners, whether they be shareholders of a corporation, partners of a partnership, members of an LLC, because each entity has its own unique set of challenges and opportunities with respect to tax structure. And really, at the end of the day, the bottom line for entity selection is tax strategy. For example, we talk about limited liability. And now, of course, there is the legal defense from legal liability aspect of a limited liability entity. But for the most part, when we think about liability, it really is a financial question. And I guess from a legal perspective, it's also, you don't want to get sued because at the end of the day, it's money out of your pocket. But when we talk about liability, we're really talking about lowercase l liability, money. How do I protect myself from being personally liable for the debts of this company? And that is so wrapped up with the specific tax situation of the ultimate beneficial owners. So I usually go through a quick and dirty analysis of the three major types. We have a corporation, an LLC, and a partnership. And the reality there is that the tax election that you make with the IRS is probably more important than the actual entity type, because a C Corp can elect to be an S Corp, an LLC can elect to be a C Corp or an S Corp, and the same is true of partnership. But it really needs to be a decision that takes all of these factors into account. And specifically, what do the beneficial owners really want to gain out of this? Because, for example, partnerships give you the flexibility to allocate gains and losses in ways that S Corps and C Corps do not. As far as protecting your wallet, a C Corp is always going to be the most protective because tax liability lives and dies at the corporate level. Now, as between S Corps and partnerships, it gets a little more complicated because S Corps are a pass-through like a partnership, but they don't provide the same kind of flexibility as the partnership taxation rules. And we often see in cannabis a scenario where there is a service partner, so to speak, and I'm using partner in the general sense, not partner in a partnership. There's a service owner and there is a capital owner, the person who's putting in the money. More often than not, the capital partner, so to speak, is a wealthy individual or a high net worth individual, and the service partner is not. Now, they may be a legacy participant with a lot of cash in a mattress or a suitcase somewhere, but they might not have a lot of money in the bank. One thing that comes with being a high net worth individual is playing the game of how do I offset gains with losses? And often a partnership is the best way to allocate those different tax needs of the individual partners. The drawback to partnership is that it runs the risk of having the greatest amount of personal liability, and you are individually liable for those taxes. But the bottom line, the key takeaway is that although many people don't find this intuitive, right, it should be. Your lawyers, your accountants should be working hand in hand with you to decide on what entity you should select so that you can form your business from the outset with a particular tax strategy in mind. And in cannabis, it really needs to be focused on how will we approach, as a business and as individual taxpayers, the gorilla in the room, which is IRC 280E.